switching gears just a little bit, let's talk about the Family Medical Leave Act.
Okay.
There's a lot of people that still don't know what it is.
Mm-hmm.
And I know that Oklahoma is a right-to-work state.
Right.
And they don't know how to go about doing this if they need it.
Okay, well, most folks don't realize the Family Leave Act doesn't apply to all employers. You have to have at least 50 employees. So if you have 49 or less employees, all the rights that are given to employees of companies that are much larger, you don't necessarily have unless your employer just wants to give them to you. So at McIntyre Law, I have 20 plus employees. The Family Leave Act doesn't apply to me. I still give leave to my employees when they have a medical urgent need or somebody's pregnant or something like that, but I'm not required to under the law. But for the companies that have more than 50, they are required to give certain amount of time for family emergency, for leave to have a baby, even to adopt. And if the companies fail to do what the act requires them to do, they can be held accountable. So it's a tough deal if you're at a company that's right on the line, because there are some companies that play games. They may have 150 employees, but instead of doing it all under the name of one company, they'll split it into 3 companies, even though they're in the same building. And they'll say, you work for Acme LLC and you work for Bovine LLC or whatever it is, but it's all one company, and they try to get around that 50 employee requirement. And so there's been litigation over that in the past as well.
What about this? Here is a scenario. Say you work for a big corporation, like multi-state. I think, each state has different labor laws.
Right.
And you want to use the Family Medical Leave Act. And before you sign the papers, you're terminated in, say, the state or state of Arizona, which is also right to work. How can a worker protect themselves if they haven't even signed the paperwork yet?
That's challenging. So the Family Leave Act is federal, so it won't matter what the individual state laws are. That act will take precedent over a state law. But you're right. In Oklahoma, we're right to work, and I can terminate an employee anytime that I want unless it violates public policy. And what I mean by that is, let's say you come into the office and you're wearing red, and I just hate the color red. I just hate it. And I tell you I don't want you to wear red, and you wear red, and I'll fire you one day because you're wearing red. That doesn't violate public policy. I can do that. It's a stupid decision to fire somebody, but I can. At the same time, if you come in and you announce to me that you're pregnant and you're going to need to have some leave, I can't fire you for that because that violates public policy. So you're right, in a right-to-work state, it's easier to terminate people. The question you have is, what then do those people do if they were about to take advantage of the Family Leave Act? And it's one of those things that's what the court system's made for. Some of these cases just end up in court. Most employees would file a lawsuit for wrongful termination under that by saying, listen, I was not fired because of this reason. I was fired because my employer knew I was about to take advantage of the Leave Act and they didn't want me to. And so you would go before court and see what a judge had to say.